The NPA is unhappy with the sentence handed down to a man convicted in a case of child pornography. I'm joined by Advocate Mzolisa Madola, who's an NPA prosecutor specializing in child justice. Advocate Madola, good evening, and thank you so much for your time. Firstly, let's just look at the considerations that the state has to take into account when weighing in cases such as this. What are the considerations?
Well, Cathy, the Constitution in Section 28 sets out that in any matter involving the child, that the child's best interest must be paramount. So in any case that has to do with the child, the first thing that we consider is the child's best interest.
What does that mean for a case like this where today the court has handed down its sentence, but we have the Teddy Bear Clinic and many others coming out and saying this simply doesn't go enough in fact, number one, in serving justice against the lives of those young girls that have now been effectively destroyed by this?
You know, Cathy, in this particular case, now the DPP's office is going to study the judgment and then make a comment after it has studied the judgment. We cannot at this point comment really on this particular judgment because the DPP's office still has to study the judgment and make a determination as to a way forward, if any, after that.
Sure. You know, you talk about the fact that when making its considerations, the courts will put the child or the victim first. But the complaint that has come through, even from activists that have been raising the issue of gender-based violence, is that our criminal justice system approach to victims and survivors of gender-based violence is one that, in fact, does not put the victim first, and it in fact recognizes the rights of the perpetrators more than it does those of victims.
You know, Cathy, our justice system does put the victims' rights as paramount, but also we have to consider the merits of the case. You know, with each and every case, the court has to look at it holistically. It doesn't just treat each and every case the same. The offender himself or herself has to be considered. His or her own background has to be considered, whether or not they are first offenders or they are not first offenders. All that information has to be considered. So it's not just a matter of looking at one side, even though the rights of the offender are also important and they are considered, but they are considered in light of everything else, including the perpetrator's own personal background as well.
But, you know, the mitigating circumstances that would weigh in here would, I imagine, be the young lives of these young girls that now have to live with the trauma of what they've gone through and potentially live with images that they didn't approve of themselves out there somewhere in the World Wide Web.
You know, Cathy, you're trying to put me in a corner to comment on this particular case, which I really cannot do at this point. All I can say is that I am sure the court had to consider everything that has to do around the case. The court cannot just consider the victim or just consider the perpetrator. The court has to look at everything else. There are laws that are set down to consider such cases. But in this particular case, for instance, there is no minimal sentence that is prescribed by the law. So it's up to the magistrate to decide what sentence to give after considering the case carefully. So we are not privy to what exactly the magistrate considered until we can study the judgment, and then we'll be able to see whether or not the NPA would like to take further steps.
Do you think that there should be a prescribed minimum sentence?
That is really up to the legislature because there are other factors to consider. So it's not, I'm not in a position to actually say whether they should be or not.
Sure.
But the legislature in these kind of cases trusts the presiding officers, that the presiding officers have a clear understanding of what the law says so that they can be able to give out just decisions.
Of course, one of the reasons why I ask that is that even though the law trusts the presiding officers to be able to adjudicate such cases efficiently, we know that not all magistrates, in fact, will deal the same way with cases such as this one. So do you think that there needs to be uniformity created by the law?
The reason why presiding officers cannot adjudicate the same is exactly what I've been saying, that the court has to look at also the background and the circumstances of the offender, because all offenders are not the same. Therefore, it means that even if the crime itself is the same, the sentence might not be the same because of the fact that the backgrounds and the circumstances of the offender are not the same. So that is also taken into account together with the offense itself. So that is the reason why magistrates or judges or presiding officers do not give out the similar sentences for similar crimes, because they have to look also at the offender.
There's a lot of care that needs to be applied when it comes to dealing with cases of this nature. Speak to me about some of the processes that you at the NPA have to engage in order to ensure that children are also protected through those processes of not just collecting evidence, but making sure that they're able to get through the trial.
Okay, the first thing that the NPA makes sure is that a suitable investigating officer is assigned to the case. By suitable, we mean an investigating officer who has experience in dealing with child witnesses, an investigator who has experience in dealing with sexual offenses. And then the investigator then will take the child to the teddy-bear clinic, where the child now will be interviewed and prepared by the teddy-bear clinic officials, the social workers who are employed there, who are trained to deal with child witnesses. And then after that, at court, there are intermediaries. The child offender will make sure that the child offender never, ever has to see the offender. The child witness, never ever has to see the offender, that the child witness is kept in a room that is child-friendly so that they are relaxed before going to court. We try to protect them from being intimidated by the environment of the court. So the NPA also plays a huge role in making sure that the child is ready and the child is relaxed enough to be able to testify in court. And the intermediary also explains exactly what the child is to expect, explains the personnel that they are going to see, explains the processes that are going to be followed, and we make sure that the child offender is prepared.
In a case like this, which could very well divide families, and you have the daughter of this convicted criminal being one of his victims, how does the NPA ensure that that child is protected, but also what are the circumstances that they then have to go back to? Do you get involved in adjudicating within the family what the future well-being of this child will be?
As the NPA, as far as, the future of the child offender and going back to the family, what circumstances the child going to find, we rely on the probation officer, we rely on the social workers, we rely even on the investigating officer, who will give us more information about the family setup, the background, but we rely more on the social workers. Now, we leave that part for the social workers because they are trained to deal with those kind of circumstances. We are trained to deal with the case itself in court, and then the future, the background, we leave to the social workers to deal with that part.
Advocate